Welcome to the Centre for Legal Innovation's Legal Techy Tuesday series. We are very excited to have Laura Keily, founder and managing director of Mediation, here with us today. Laura will be demonstrating Mediation's highly tailored video conference and dispute management platform. Again, welcome. Fabulous to have you here. And now over to Laura.
Thank you, Christine. Good morning, everybody. My name is Laura Keily. As Christine said, I'm the founder and managing director of Mediation. I'm also a barrister of the Victorian Bar, and I've been asked to give a brief overview as to why I started the company and the platform before giving you a demonstration today. So I started Mediation 3 years ago, and the reason was that having had a long career as an M&A lawyer doing commercial deals, I really enjoyed coming to the bar 7 years ago and loved the advocacy and being on my feet for clients. But I guess I found that some of the things about litigation tended to inhibit commercial deal making, and often I found that I was trying to settle matters for clients who had spent more money on legal fees than on the value of the dispute itself, and that made the dispute an intractable one. And many of us as lawyers are familiar with that state of affairs. But I thought that perhaps the timing was right. This is 3 years ago now, given the power of cloud-based systems and given the progress that had been made in legal technology, that perhaps there could be a platform that helped people resolve disputes more quickly and easily where it was appropriate to do so. And so I set about creating Mediation then to provide a really fast and easy way for people who were resolution focused to resolve disputes online. And our original plan was that we would have a panel of people involved in helicoptering in, really, at an early stage of that dispute and helping people resolve it. And so we set about curating a panel, which is on our website, and I'll just bring it up now. And you can see some highly esteemed panel members, and feel free to go through them at your leisure. But the idea behind this panel was that they would resolve disputes on our platform for a fixed fee and in a fixed time frame. And for the same amount of time and the same amount of money as it would often take for one party to go and hire a litigator to run a dispute, they could, in the right case, actually resolve it on the platform with their lawyers or without them if they couldn't afford lawyers. And so in September last year, we launched that service, and it's called the Mediation Panel Service. What's happened in COVID is that we've pivoted quite a bit. So the panel service for fixed price commercial mediation is in play and is being used by people. And you'll see here it's our first offering on the platform, and it is a fixed fee that's related to the value of the dispute, so ad valorem pricing. So if you are a client, an end client, an in-house counsel, or you are a solicitor and you would like a full service to use the platform and use the technology and have your matter arbitrated or mediated for you, that service is available. But like I said, during COVID was presenting really interesting challenges for the industry, and in particular for many lawyers and mediators and arbitrators who had existing matters on the go. And so they may not have needed necessarily a member of our panel because everything was ready. But they required a platform to facilitate that dispute resolution. And so we pivoted to really facilitate the profession using the platform in a new way. And we've called that our managed service. So in that particular offering, what we do is provide everything that a lawyer or mediator needs to have that dispute run successfully on our platform, and that all they need to do is focus on the matter itself. So that includes a legally trained person, usually a first or second year lawyer or a law graduate, sitting in running the matter for them on the platform. And we found that to be really useful, particularly for litigators who are able to pass on that fee as a disbursement to their client. So it doesn't hit them, but it's very useful for them in that respect. We have a number of other offerings which I'll get to a bit later, but they largely centre around providing the platform on an enterprise basis into government and into courts and tribunals. And I'll just touch on that briefly. The reason I think it's important is because we have been providing this into the Commonwealth courts and into some of the local courts in Victoria, which has given us a great deal of learning as to how best to adapt court craft and tribunal craft into an online environment. So it's useful, I guess, if you come up against or in touch with the platform through a court or tribunal, where you don't pay for it necessarily because the court or tribunal is subscribing, but the same functionalities exist, which we then find feeds back into people's private work, and they then want to engage it as a managed service or panel service. So just with that broad overview in mind, I'll just take you into our first platform. So this is our first generation Immediation platform, and I've got a couple of team members there. You'll see Zahava Heinrich, who heads up our legal operations, and Jennifer Migliori, who's in our product selection team. So they are both now currently inside our first generation Immediation platform, and this is the one that we make available on the managed service, for the panel service, and also into the enterprise offering within courts. So a couple of key points to note. This is, in this instance, an advanced video conferencing capability. In the panel service itself, we actually have a document intake and an information exchange, the appointment of the mediator and arbitrator and so on, which is also on the platform. But for the purposes of today, I thought I would just share with you the end game of what happens when you go through that intake process, being the advanced video conference tool. And it's this advanced video conference tool that we also make available to courts, tribunals, and to our private clients in the managed service. So there are a number of distinguishing features about our platform which make it particularly good for dispute resolution. The most obvious is that the dispute, and you can't see it in this instance because it's just called demo, but ordinarily we set up the dispute so that the case name reflects exactly what's happening in real life. So if you've got plaintiff versus defendant 1 and 2, you will see that as your case name. Each participant on the conference is also set up in their client lawyer team. And so there are effectively 3 ways that we refer to a person who is a participant in one of our matters. They are labelled with their name, and that's entirely bespoke. So it can be, the Honourable Marilyn Warren, or it can be, Joe Blow QC. Whatever is required to refer to that person correctly is what we do. There's another label here which says neutral party, respondent, claimant. So the platform actually has 3 or 4 broad categories, and everybody who comes onto the platform is aligned in one of those. So you're either a claimant or an applicant or a plaintiff. You're a respondent or a defendant. You are a neutral party, so a mediator, a judge, or an arbitrator. Or we're actually about to add a 4th category called, perversely, third parties, which are people who are involved in the dispute but are not fitting in one of those categories. So for an example, an objector in a planning matter. And so the platform will always align every participant with one of those 3 or 4 categories. You then have the 3rd label, which is actually your title in relation to this dispute. So it may be that you are, for example, the lead arbitrator. It may be that you are, a registrar. And so you'll always be correctly called by your appropriate title in this dispute. We find that that's really important when you get to 15, 20, 25 participants on the matters, because it gives the neutral party confidence that the people appearing in front of them are the right people. Also, in the back end of the platform, the client lawyer teams are arranged so that they always stay together. And that's really important when we get to things like the private room functionality and for the sharing of documentation. A few other factors about these tiles that you see down the bottom here. This is currently arranged in predominant speaker view, so which is very useful, for example, if counsel are making submissions, that you can see them in large format. You can also see all of the participants who are involved running along the bottom. And when there are more than what your screen will allow, there's a scroll bar, so you can always see all participants, and that goes up to 50. It will just continue scrolling. We've also, however, now got a second view, which is gallery view. So if I hit enable gallery, you can see everybody's moved into a tile that's approximately the same size. But what we can also do is you can order people the way you want to see them. So if you imagine you had 50 people in this gallery, you may not want to look at them all. What you can do is what we call pin people in the order that you wish to see them. So for example, I'm going to move Zahava up to be next to me. So you could, for example, if you were a mediator, you could have all of the applicants at the top or all of the respondents at the bottom. You could alternatively have just the two counsel. And so you can arrange people in the way that you wish to see them. And we believe that's a market leading feature at the moment. So a couple of other features while I'm focused on the people. On these tiles, you can see that everybody can turn their camera off and can mute themselves. That's now fairly standard. One other feature though that we have, which only the neutral parties can do, is they can mute people, force mute them, and they can't turn themselves off. That's really important for a couple of reasons. It can be useful in a very antagonistic mediation context where somebody needs to be controlled, but it's also really useful where people are unaware of the background that they have, maybe causing problems for other people. And so that's one of our two superpowers that neutrals have on our platform. The other superpower that neutral parties have on our platform is that they can move people in and out of private rooms. We are of the firm belief that the neutral parties in control of proceedings should be the ones who can move parties around on the platform. That's really important, particularly in a mediation context. So this has been designed so that the mediators can hold joint session where everybody's together. And then when they're ready, they can move people into private rooms. You'll see at the moment everyone is in the lobby. That is quite deliberate so that you can have a space where people can sit and wait if necessary. And then ordinarily what the mediator would do is they would invite everyone into the main room. The main room is where joint sessions happen. What can then happen is, and I'll just show you there, we're all going to move into the main room. Everybody needs to accept their invitation to move. Might just be a little slow because you're looking at a screen through a screen here. And you might have just seen there, it just said transitioning. So the mediator can always see, or the neutral party can always see what's going on in this rooms tab and can control it. So everybody's now moved into the main room. So Harvey, I'll just get you to say something again. Sorry, it disappeared. I'm not quite sure what's going on. Just leave that for a moment. So we'll just move to now showing you the private room features which are more adapted for dispute resolution. So what the mediator can then do is hit this button that says invite claimants to room, and that will put all of the people who are in the claimant team into a private room on their own. Same with the respondents. If it's a multi-party matter, so more than one claimant or plaintiff or more than one defendant, there will be shortcut keys not only for all of the people on the plaintiff side and all of the people on the defendant side, but each individual plaintiff or defendant team, and those shortcut keys will show here. Then as a further level of adaptation or flexibility, the mediator can move any one individual into a different room. So for example, if Zahava was counsel and she wanted to talk to counsel only, she could move the counsel into room 1 and off they would go. And as a mediator, I could then pop into room 1 and have my conversation with counsel only. So we found that a very good way of managing very large scale mediations involving multiple parties in multiple jurisdictions, and it also enables lawyers to communicate with their clients privately should they wish to do so, even if they're not in the same location. The platform has a number of other features which enable communication. Again, there is something you'd be quite familiar with from other big tech platforms, which is public and private chat. So you can chat with everybody, or you can chat with one person. Throughout the mediation or the hearing. We find that this is very useful for communications, particularly when lawyers are not co-located with their clients, so that they can be continually talking about settlement offers, for example, without disrupting the flow of what's going on in the matter. Other tabs that you'll see along here on the top right-hand side, the attachments tab, we can introduce documents onto the platform in a couple of ways. We can do it prior to the matter. There's a portal where people can see the matter that's coming up and they can drag and drop. So, however, I might get you to just add something. Hopefully it's quick enough today with all of these different screens going on that it will appear. And we can also add it during the matter itself. When a document is uploaded, it will automatically default to being viewable only by that person's team. So when I mentioned we set up the client lawyer teams. So Sahava's just uploaded the troubleshooting guide there. You can see at the moment, everybody has access to that document. So she's changed the default to everybody. And I can then download that onto my screen. You'll see that that appears down here. But Sahava can also share that only with her client lawyer team if she wishes to, and then change the setting so that it instantly goes from being private. So she's just made it private, so I can't see it. She can change it from private to public. We have an additional functionality, which is that there is a settlement agreement embedded into the platform. And that is a very vanilla settlement agreement. I can show you the pro formas on our platform. It's also here on the website. There's both a binding settlement agreement template and a heads of agreement template. Just quickly pull up the settlement agreement template. You can see it's a very standard document which the parties have agreed to settle the dispute without any liability admission for payment of a monetary sum or any other terms. There's a default clause, confidentiality, non-disparagement, mutual release, barter proceedings, etc. And at the back, there is a schedule, which is a standard schedule of the commercial matters which would differ between the parties in any dispute. In order to speed up the process of entering into that settlement agreement, we've built this functionality that enables co-drafting on the platform. So the neutral party can set somebody as the scribe. I'll just set myself for now. And then they can actually design execution clauses, but we'll come to that in a moment. You can see those 16 fields in the back of the settlement agreement appear here on the screen. And so, for example, settlement sum can be drafted. I've made it $10,000. Sahava, if she was a lawyer, might then wish to add some additional settlement terms and she might wish to draft them. So I can then change the scribe to Sahava. You'll see that the text flipped over to slightly different font, and I'll get Sahava to now type in the settlement terms. And you should be able to see, if my internet speed is fast enough today, Sahava typing in there in real time. So in this way, we can co-draft settlement terms really effectively. You can hopefully now see her drafting in there. And when the parties are finished, they've passed the pen around as much as they wish, the neutral party can select execution clauses which are adapted for all of the circumstances you can imagine. So, for example, if your claimant is a company, you can select a company clause. You can type in what the name of the company is and select from a variety of signees, authorised signatories, director and secretary, and so on. You'll note here that we have a section 127 signature block, but with COVID, section 127 signatures electronically are actually valid, but ordinarily we would recommend that they be signed in wet ink again. And there's a warning that comes up about that. So what will then happen is you will get a signature request sent out through the platform to the people on the call, or indeed other people. So it may be that, for example, the CEO is not present in the mediation but the settlement has gone above the delegated authority of the representative that was sent along. And so you may wish to actually add somebody else. See here, I've just typed in other. So it might be that other CEO gets sent an email request to sign the document. And you can add as many signatories as you need. We did this because we really wanted to have the ability to sign on the platform and keep people in the moment, but we weren't happy with a bog standard DocuSign integration. So we built this specifically for dispute resolution purposes. So when the mediator is content and all the parties are content, the mediator hits finish terms and request signatures. The platform creates the settlement agreement, populates it with the fields that have been agreed, and requests DocuSign signatures from all of the parties who have been requested. You can start again if you make a mistake by hitting void document and update terms, or you can wait for the signatures to be done. And the second one was just a made up one, so that probably won't come up as signed. In any case, I will just show you the settlement agreement populated with those fields that we were working on there. It's a similar thing with the heads of agreement next door on the platform there. It's just a non-binding heads of agreement. We also have the ability, and we did this for courts to be able to draft orders, but in effect, this is a blank document field. So it enables a fully blank document to be drafted and signed, which you can imagine could be quite useful in a variety of settings, for at least for a short document, in much the same way. I've been through the roster, which is the gallery and the rooms. So they're the key functionalities of the platform for dispute resolution in video conferencing, at least. There is one more thing I'll show you here, which is that there is a screen share function. Everybody has that screen share function. If I hit screen share now, it might get very confused because I'm already screen sharing through Zoom, so I won't do that, but that's obviously very useful if there's no a document that's not already uploaded to the platform that people want to look at. I think I mentioned at the beginning that we have a couple of platforms. The first was the first generation one I've just shown you, which we use for our panel service. We also use for our managed service, and we use for our enterprise intercourts. We could see that we needed to provide a subscription-based platform for the market because many people were asking us for a platform, particularly mediators, where they could create a version of our platform for their own use. So we created a second version of the platform, which is effectively our second generation, and we call that Dealmaker. The reason we call it Dealmaker is because we like this concept that you can transform disputes into deals really effectively using this technology. And in fact, it does have broader application in the drafting, co-drafting and negotiation of agreements that go beyond disputes and settlement agreements. So it's a fairly simple, this is the beta version of the platform, which was recently released. And what you can do as a mediator or a lawyer is create a matter. It's pretty intuitive. So you can create effectively a case on the platform in your own words with your own custom reference numbers. You can do things like say, I'm using this on behalf of a company. You can, for example, say that it's already in court. You can select from a variety of different types of things that you would use the platform for. And all of this information gets recorded by the platform and then sent out to the people who are going to attend. So for example, if you wanted to say that this was an arbitration, the platform asks what your role in the matter is. So in this case, you may say, I'm a neutral party. I'm in fact the arbitrator. You can then add other parties. So it asks you who you wish to contact, who else are you going to invite to the matter. And you can go ahead and invite all sorts, everybody that you want to add. So obviously the parties, other arbitrators on the panel, etc. and it asks you who they are. Are they a party? Are they a representative? Are they a witness? And so on. If they're a representative, it will say which type of representative. So it will give you all of the different parties so that you can, for example, label first party, second party, and so on. And it gives you the ability to continue adding until you have finished. At the moment, only the person who is a subscriber in the beta version of the platform has the ability to control the platform. We'll be building that out soon so that you can add, for example, if you were a lawyer, a senior associate at a firm, and you wanted to set up a mediation, and you wanted to invite a mediator to participate, and you wanted to give them the ability to run the meeting, you could give them the neutral party the controls. It then says, do you want to upload any information? Everybody has the ability to upload information when they get the invitation. And is there anything that you would like to say? So I might have uploaded a position paper, or, you know, if you were the arbitrator, you might have uploaded draft preliminary orders, for example. There's a sort of mini discovery by consent. Is there anything that you're waiting for? Just to prompt the other party to provide it. For example, to speed up communication so you don't have to send a long email as well. It then gives you the ability to schedule the matter, and then tells you you're good to go. So we'll present a summary of all the people that you've invited, what their role is, what their email address is, the date of your meeting, and then you hit submit. It creates the matter on the platform and emails all of the people, all of the information that you've provided. So it will say you've been invited to a matter on the platform. This is what the matter is. This is what it's about. You've been requested to provide the following documents. These documents have been provided by the person who invited you, and so on. And so you can see that matter's already instantly there. And you can edit it. You can go into it, which is show, or you can delete it. So you can see now that everybody's in the other platform. It's very similar in that the core functionalities are the same. You can label the matter, you can label the people, you can share your screen. And what it has done is make a little bit of this functionality a bit snappier. So the private room functionality off to the side, for example, so it's responsive. And you can actually create a private room as a mediator, call it whatever you want. You can set these up in advance. And then you can move people into the room. So I'll just go ahead and move Jen and Zahava into the room, and you'll see them disappear into the private room. So that's very easy to use. And it's designed not to be quite as prescriptive as what we have on the main platform, and a little bit more flexible. You can see that it thinks while it's moving people around. And that's because what it's actually doing is reconnecting with your browser to make sure you're securely moved into a different room and you've disconnected from the previous conversation. On the other side of the screen, we have additional resources. We have chat. On this platform, we actually have chat between the participants as individuals, or between the council only room here, or any of the rooms. So there's both individual and room chat. The files are very similar. You can upload files either beforehand or in the moment, and it will say who's uploaded them, and that can then be downloaded. And again, the agreements, we have a similar functionality that you can create the settlement agreement and fill in the fields, and go through the same process of creating execution clauses and signing that agreement. So that platform is available on a subscription basis, which is $149 per month for unlimited use. It's really great for mediators who have their own practice and who would like something a little bit more bespoke than the standard big tech offerings that are currently available, that makes their job much easier and more streamlined, and yet still provides really great video conferencing tools. I will briefly, as I think we have the time, show you a couple of other things inside the Dealmaker platform itself. So you can see here we're on the dashboard for that particular matter. You can do a number of things from this dashboard. There's a pre-meeting room, which we have on both platforms actually, where you can use it to quickly go in whenever you like with any particular party beforehand. You can add somebody if you forgot them. You can edit their details. You can reschedule the matter. You can add attachments and evidence, upload directly from your device. And there are other resources here, such as the settlement agreement that we were in the middle of drafting and signing. If you go back to the list, you can see here all of the matters that were on the platform, and this is your effectively like your case management within that platform. If I go back to the original, you'll recall that I said that the original concept was to create this panel service whereby people could exchange information about a claim and appoint a member of our panel. The most, I guess, effective for end clients tended to be that they could do everything that they needed to do on the platform from start to finish. And so they do have the ability to create a claim on the platform from the start. So what this does is actually not replace, but supplement how lawyers interact with one another and engage through a document sharing and information exchange process, and enable the appointment of a mediator or arbitrator on our platform entirely through the platform itself without the need for other correspondence. So if I hit create claim, bearing in mind this is in a world where I don't have a mediator or arbitrator appointed, but I would like to use the fixed fee panel. You start from the beginning, and this is drafted on the basis that the respondent knows nothing about what it is that you're about to claim. So you're effectively starting from the beginning. You're saying that you want to handle this dispute by way of mediation. Arbitration is about to be built out here, as is a family offering. So we're currently working with Family Property, whom many of you may know, on an integration of the family property technology to broaden this out from just commercial mediations and arbitrations into the family market as well. So this intake process will be duplicated, if you like, for family law contexts. But you're going right back to the beginning. You're explaining the nature of the dispute, how it happened, what the key facts are, and what arguments you could make in support of your claim, almost like a lawyer's letter combined with a pleading. It doesn't like me trying to skip over bits. Again, you can upload documents and information. You can explain why these documents are relevant to your case. Ask for anything from the other side. It then asks you what a successful resolution of the dispute looks like to you. And this is a little bit like a pleading where you're asking for a remedy, or it could be that it's describing the outcome that you're wanting from an amicable dispute. So, you know, you might just say, I want to be, it can be as simple as that. The platform then calculates our fee. So as I said at the beginning, the fee for this particular panel service is on an ad valorem basis relative to the value of the dispute. And we did this because we're trying to break down this concept that that legal fees could well exceed what was reasonable, or resolution fees rather than legal, could well exceed what was reasonable on a smaller dispute. So obviously we've got to guide the parties as to what their dispute value might be. And we base the price off what the claimant says the value is. That's for a very good reason. The respondent might say that the value of the dispute is nil, but the actual objective value of the dispute itself is still, in this case, $100,000. It then asks you who the respondent is, and this is because the platform will actually communicate with the respondent for you in a very non-aggressive way. It will say in our email, it says, the claimant says that they have a dispute with you. Are you open to resolving it on the platform? You don't have to pay anything at this point in time. If yes, if you would like to explore this as an option, please continue. And then there's all sorts of information about the method provided to the person. So it's very non-aggressive. It enables the party to select when they're not available for mediation. The reason being that each side can say up to 5 dates they're not available in the next month, leaving the mediator with a 2-week window, if you're using our process, to select a date for mediation within 30 days from the date that the parties agree. That's really important for us because on this model, we wanted to have a finite time frame within which mediation would be attempted. So the panel member who accepts the appointment on our platform will have contracted that if they say yes to that brief, they will be available within the next 30 days, so that there's always an end in mind for these people. The platform has now calculated the fee based off the data that I input. And at this point, I can then actually split the fee. So I, as the claimant, can say, I'd like to pay for all of it, or I'd like to ask the respondent to pay half. Or in the event that I know, for example, I've come up against an insurance company and the insurance company's offered to pay, I'm going to actually ask them to pay for all of it. And then this is the immediately pre-submission page, but it's now told you that the fees have been split. And it will then go ahead and submit to us at a mediation a draft of that claim on our platform. We will always approve it before anything is sent to the respondent because we don't want to have any spam or anything that doesn't look legitimate on the platform. The respondent would then receive an invitation to participate in a dispute. They would be able to respond to the things that the claimant has said. They, if they wish, would be able to submit a counterclaim. The platform calculates the fees on the same basis and charges an uplift if there is any, if the counterclaim exceeds the value of the claim by a significant margin. The platform then lets us know that we can present a mediator from our panel as somebody who would be available. The parties then approve that mediator or they can decline them. If they decline them, they can decline them for any reason at all. We'll just continue to present another person until such time. I think we allow 3 declines before we say, look, maybe this is not the right method for you. At that point, there is an electronic mediation agreement, which the parties present for signing. And then it's only at that point that the fees are collected. So when the parties have agreed to the mediator, they know how much they're going to be charged. They've both approved it and they've both agreed to the date and the mediation agreement has been signed. The platform will then present through a Stripe integration a request for payment of the fees. Those fees are then taken. They include the fees of the mediator themselves, and then the mediator will proceed to hear the matter on the platform, and the parties will go forward from there.
Thanks, Laura. That was a really interesting demonstration. So it was really interesting to hear why you built the Mediation platform and how it has been used by participants from countries over the world to improve access to justice inside and outside the courts. A huge thank you to all of you who have attended today. As you know, the Centre for Legal Innovation is very much focused on these types of webinars, this type of information sharing, collaboration and experience exchange. We are all about practical solutions. There will be many more webinars coming up in the Legal Techy Tuesday series in 2020, so don't forget to follow us on LinkedIn, Twitter or Facebook for announcements. We look forward to welcoming you back to one of our events, and thank you again very much for joining us today. Thanks, Laura.
Thank you.